All right, diving right in today, we're taking a close look at a pretty impactful Supreme Court case.
Definitely a big one.
This is Nieves v. Bartlett.
Yeah, this case really gets to the heart of First Amendment rights, freedom of speech, and how that all plays out when you're talking about arrests.
Yeah, so the core issue here is if the police had a good reason, like a solid legal basis to arrest someone, does that completely shut down any claim that the arrest was actually retaliation for something the person said?
Right. Was the arrest truly justified, or were they just using it as an excuse to punish someone for, speaking their mind?
Exactly. So the Supreme Court had to figure out where to draw the line, and their decision actually ended up being pretty nuanced. It wasn't a straightforward yes or no.
Definitely not black and white. What they essentially landed on was that having probable cause, that legal justification for the arrest, is a pretty strong defense against a retaliatory arrest claim, but it's not an absolute guarantee. It's not a get out of jail free card, so to speak. There's a very specific kind of limited way that someone can still try to argue that they were retaliated against, even if there was probable cause.
Okay, so before we dive into that exception and how it all works, let's back up for a second and make sure everyone's on the same page. So legally speaking, what was the main question the justices were trying to answer?
The big question was whether the simple fact that an officer could have arrested someone for a legitimate reason, like they had probable cause. And just to clarify for anyone who might not be familiar with the term, probable cause is basically a reasonable belief based on facts that a crime happened or is happening. Should that totally shut down any claim of First Amendment retaliation right then and there?
So, is probable cause an automatic game over for that kind of claim?
Yeah, that was the big debate. The person bringing the case, the petitioner, argued for a very clear-cut rule. They basically said, if the police had probable cause, the officer's personal reasons, their motivations shouldn't even matter. The retaliatory arrest claim should just fail. Case closed.
So they were saying that as long as the police had a legal reason to make the arrest, whatever was going through their head, their personal feelings about the person they're arresting shouldn't be considered.
Right. And they had some strong arguments for that position. For one thing, they pointed out how difficult it is to actually prove why an officer did what they did. How can you really know what was going on in their mind at that exact moment? They argued that trying to figure out an officer's motives is a lot of guesswork, a lot of assumptions, and it could lead to unfair accusations.
Yeah, I can see how that would be a concern from a law enforcement perspective.
Right. And their second big argument was about the practical side of policing. They said officers need to be able to make lawful arrests that are based on probable cause, without constantly worrying that someone's going to come after them and question their every move, their every thought. They argued that if the arrest is legally sound, that should be the end of it. And they even brought up the history of legal tradition, the idea that if an arrest is justified by probable cause, that's always been considered enough.
So that perspective emphasizes the need for police to be able to do their jobs without being second-guessed at every turn. But what about the other side of the coin? What were the arguments against having this hard and fast rule that probable cause is always the deciding factor?
Well, on the flip side, people were worried about the potential for abuse. Their concern was that if probable cause always trumps everything else, it could give officers a way to target people for expressing views they don't like, even if it's under the guise of a legitimate arrest.
So imagine if you're at a protest, you say something critical of the police, and then bam, they arrest you for jaywalking, even though you probably weren't the only one jaywalking.
Exactly. Or maybe you're pulled over for a minor traffic violation after, putting a bumper sticker on your car that's critical of a certain policy. The argument is that the real reason for these arrests isn't the jaywalking or the broken taillight. It's about silencing someone or punishing them for their speech. And they argued that the First Amendment should protect against that kind of retaliation, even if there was technically a legal reason for the arrest.
So the focus shouldn't just be on whether the officer had a legal basis for the arrest, but also on whether they were using that legal basis as a cover for something else entirely.
Right. And they argued that probable cause shouldn't be a shield for that kind of targeted enforcement. It's about ensuring that even when there's a minor legal violation, the police aren't using that as an excuse to go after someone for their speech.
And this whole issue of minor offenses being used selectively came up a lot during the oral arguments. I remember several of the justices really digging into this and trying to figure out how to balance these competing interests.
Oh, absolutely. Justice Sotomayor, for instance, raised a really interesting point about how First Amendment retaliation claims should be viewed in comparison to, say, a claim of racial discrimination.
Like, are we giving First Amendment rights the same level of protection as other fundamental rights?
Exactly. She pointed out that in discrimination cases, it's widely accepted that there can be multiple factors at play, that things aren't always clear-cut. Even if there's a legitimate reason for an action, if discriminatory intent was also a significant factor, the person can still win their case. So her question was essentially, why should it be any different for a First Amendment right? Why should that be viewed as somehow less important or less worthy of protection?
It's a thought-provoking question. It makes you think about whether we're implicitly creating a hierarchy of rights when we set the rules for how to prove violations.
For sure. And it raises the question of whether the current legal framework adequately considers the chilling effect that this kind of potential retaliation could have on free speech. If people are afraid to speak out because they think they might be targeted for a minor offense, that's a problem for everyone.
And on that note, I remember Justice Alito seeming particularly concerned about this idea of pretextual arrests, where, as we were saying, the stated reason for the arrest might be technically valid, but it's not the real reason.
Yeah, Justice Alito really dug into that. He brought up scenarios where an officer might, be looking for any excuse, any tiny little infraction to arrest someone specifically because they said something that the officer didn't like. He questioned how practical it would be to try to figure out if no reasonable officer would have made the arrest under the same circumstances if the speech hadn't happened. It seemed like he was worried about, how do you measure that? How do you know? And what if different judges interpret that differently? He was concerned about it being too subjective and potentially leading to inconsistent outcomes.
So how do you create a standard that's clear enough for everyone to understand and apply consistently?
Right, that's the challenge. And then Justice Kagan, she brought up an example that I think really illustrates the heart of the issue.
Lay it on us.
She talked about the scenario of someone being arrested for jaywalking right after they said something critical of the police or expressed an unpopular opinion.
Ah, that's the classic example. Everyone can picture that.
Right. It just gets to the core of what people are worried about, that even if there's probable cause for a minor offense, officers might use that as a way to silence dissent or punish people for exercising their First Amendment rights.
Yeah, it raises the question of whether that minor offense would even been noticed or acted upon if the speech hadn't happened.
Exactly. And so the justices were really trying to come up with a way to prevent those kinds of situations, those clear instances of retaliation, without tying the hands of officers who are making legitimate arrests. I think Justice Breyer put it well when he said something along the lines of, we need to find that sweet spot, that middle ground where we can protect free speech without preventing law enforcement from doing their job effectively.
Right, that's the balancing act they're always trying to strike.
Yeah.
So what were some of the ideas that came up for how to achieve that balance, that middle ground?
Well, Justice Breyer, he floated a few possible compromises. He suggested maybe looking for objective signs that the reason given for the arrest wasn't the real reason. Situations where the way the law was enforced just seemed really out of the ordinary compared to how similar minor offenses are usually handled. Is this something they typically track down on, or does it seem like they're singling this person out? He also brought up the Devon-Peck rule, which deals with when exactly an officer has to say what law they're arresting someone under. It seemed like he was thinking about ways to, limit the reasons an officer could give after the fact to justify an arrest, which could help prevent them from coming up with justifications later on that weren't really the reason at the time.
So kind of closing off those loopholes where they might try to come up with a different reason after the fact.
Yeah, exactly. And it's interesting how they're trying to take these existing legal principles and apply them to this new context, this evolving understanding of how the First Amendment plays out in everyday interactions with the police.
And it's worth noting that they also discussed how another court, the Ninth Circuit Court of Appeals, had been handling these kinds of cases. It sounded like they were a bit more open to allowing retaliatory arrest claims to move forward, even when there was probable cause.
Yeah, the Ninth Circuit had kind of a lower bar for these cases, meaning it was a bit easier for someone claiming retaliation to have their case heard in court, even if there was probable cause for the arrest.
So they weren't automatically dismissing those cases just because probable cause existed.
Right. And there was some debate about whether that approach was consistent with the Supreme Court's own rules for when a judge can dismiss a case without a full trial, what's called summary judgment. Some people argued that the Ninth Circuit was basically making it easier for plaintiffs in these specific types of cases, which might not be fair to the other side.
And then there was this Mount Healthy test that kept coming up. Can you give us a quick breakdown of what that is and why it was relevant to this whole discussion? I know it's probably not a term most people hear every day.
Yeah, the Mount Healthy test is basically a legal framework that courts use in First Amendment retaliation cases, especially when you're talking about government employees like teachers or firefighters. But the concept is relevant here too.
So how does it work?
It essentially says that the person claiming they were retaliated against has to show that their protected speech, the thing they said or did, was a major reason why they were treated unfairly. Like in this case, they'd have to show that their speech was a big reason why they were arrested. However, there's a catch. Even if they can show that, the other side, in this case the police, can still win if they can prove they would have taken the same action anyway, regardless of the speech. So, maybe they would have arrested the person for jaywalking, even if they hadn't said anything critical. Gets tricky.
So it adds a whole other layer of complexity. You have to try to figure out what the real primary reason for the action was. Was it the speech, or was it something else, or was it some combination of factors?
Yeah, and in the Nieves case, the big question was how this idea of but-for causation, meaning would the arrest have happened specifically because of the speech? And the officer's motivation should be considered when probable cause was already there. Like if they had a legitimate reason to make the arrest, how much weight should the officer's personal feelings about the person's speech carry?
It's a really tough question. And it's easy to see why the justices spent so much time wrestling with it.
Yeah.
And on top of all that, they also touched on something that's becoming more and more important in these kinds of situations: technology.
Oh, yeah. They talked about how things like body cameras and video recordings from bystanders can potentially play a big role in figuring out what really happened.
Right, like the video might show what was said, how the officer was acting, all those little details that could help determine whether the arrest was legitimate or if something else was going on.
Exactly. It could help cut through some of the uncertainty and speculation about the officer's intent. Like, if you can see and hear what happened, it might be easier to figure out if the arrest was justified or if it was more about retaliating for something the person said.
And this idea of the practical consequences of whatever rule they came up with was a big part of the discussion too, both in terms of the potential for more lawsuits and the impact on how police officers do their jobs out in the field.
Absolutely. There was concern that if it's too easy to sue for retaliatory arrest, even in cases where the police had probable cause, it could lead to officers being hesitant to make any arrests, even when they're justified. Like, they might be afraid to act because they're worried about ending up in court.
So it could make them second guess themselves, even when they're doing what they're supposed to do.
Right. But on the other hand, if it's too hard to bring these kinds of claims, then there's a risk that officers could abuse their power, knowing that they can basically get away with retaliating against people as long as they can find some legal justification for the arrest.
So the court had to weigh these different outcomes and try to find the best way to protect both individual rights and the ability of the police to do their jobs effectively.
Yeah, and it's interesting that they even went back and looked at how things were handled in the past, like under older legal systems. They talked about how arrests for misdemeanors and felonies were treated and whether probable cause was considered a defense back then. It's like they were trying to see if there were any lessons they could learn from how these things were dealt with historically.
So they were looking to legal history for guidance.
Exactly. The person bringing the case, they argued that way back when, under common law, probable cause wasn't actually a defense to a wrongful arrest if the arrest was for a misdemeanor, like a less serious offense. And since the arrest in this case, in Nieves, was for a misdemeanor, they argued that it supported their position that probable cause shouldn't be an automatic game over for the retaliatory arrest claim.
It's like they were saying, hey, look, even back in the day, probable cause wasn't always the be-all and end-all. But, of course, there's always another side to every argument.
Right, and the other side pushed back on that interpretation of legal history. They argued that things were different back then and that the common law didn't really apply in the same way to this case.
And then there was this whole discussion about serious offenses versus petty offenses. Like, should the probable cause rule be applied differently depending on the severity of the crime?
Yeah, that was another idea that came up. Some people argued that maybe for serious crimes like, assault or robbery, where there's a greater need for immediate action, a stricter probable cause requirement makes sense. But for really minor offenses, things like jaywalking or littering, where the need to arrest someone right away might not be as strong, maybe there should be more leeway for someone to claim that the arrest was really about retaliation.
So the context of the arrest should be taken into account.
Exactly. And finally, there is a brief mention of the fact that ultimately it could be up to Congress, the lawmakers, to step in and create more specific rules for how these kinds of civil rights claims should be handled.
So the court acknowledged that they're interpreting the law as it exists, but they also recognize that Congress could come in and change the law if they wanted to.
Right. That's always a possibility with these legal issues, the interplay between the courts and the legislature. But for now, we have the Supreme Court's ruling in Nieves to work with.
So let's get to the decision. After all that back and forth, all that deliberation, what did the court actually decide? As we said earlier, they didn't say that probable cause always wins, but they also didn't fully go along with the Ninth Circuit's more lenient approach.
Right. It was somewhere in between. Their decision was that generally speaking, if there's probable cause for an arrest, the retaliatory arrest claim will fail. So in most cases, that probable cause is going to be enough for the police to be in the clear. But there's a big however.
Okay, lay it on us. What's the catch?
The catch is that there's one specific exception where the person claiming retaliation can still win their case. They have to present strong, objective evidence showing that other people in similar situations who didn't say or do anything that would be considered protected speech, they wouldn't have been arrested under the same circumstances.
Okay, so that's the key. They have to prove that they were treated differently because of their speech.
Right. It's not enough to just say, I was arrested after I criticized the police, therefore it was retaliation. They have to show a pattern of how the police typically handle these situations and demonstrate that they were singled out because of their speech.
So it's a high bar, but it's not impossible to clear.
Exactly. And the court really emphasized that it's not about trying to read the officer's mind or guess what their motivations were. It's about looking at the facts, the evidence, and seeing if there's a clear pattern of differential treatment.
So after this deep dive into Nieves v. Bartlett, it's clear that this issue of the First Amendment and law enforcement is far from settled.
Oh yeah, it's a constantly evolving area of the law, and this case just highlights how difficult it is to find that right balance between protecting free speech and ensuring that the police can do their jobs effectively.
And the questions the justices raised during the oral arguments, those really illustrate the challenges involved in creating a rule that's fair, workable, and takes all those competing interests into account.
For sure. And I think for us as citizens, it's important to understand these nuances, these complexities, because it affects all of us. It's about our fundamental rights, and it's about how we interact with law enforcement in our everyday lives.
So in light of all this, what do you think are the biggest takeaways from this case? And what questions should we, as engaged citizens, be thinking about going forward?
I think one of the biggest takeaways is that while the court recognizes the potential for retaliatory arrests, they're also setting a pretty high bar for proving that retaliation, especially when probable cause exists. It's a reminder that we have these rights, but asserting them and protecting them can be an uphill battle. It also raises questions about what kind of evidence is going to be considered sufficient to meet this new standard, and whether this approach really does enough to safeguard free speech, especially in those more minor everyday encounters with the police.
Yeah, that's a key point. And it makes you wonder what this means for people who might not have the resources or the knowledge to gather that kind of evidence.
Absolutely. It's something to think about. And it also makes you wonder if there are other ways to address this issue, like maybe through police training or stricter departmental policies to try to prevent retaliatory arrests from happening in the first place.
Those are all excellent points. Well, that brings us to our favorite segment, the 10th chair. This is where we get to put on our Supreme Court robes, so to speak, and imagine ourselves as a justice deciding this very case. So if you were the 10th justice hearing Nieves v. Bartlett, what would your perspective have been, and what might your proposed solution have been?
Ooh, that's a tough one, but I'll give it a shot. If I were sitting on that 10th chair, I think I would have been inclined to take a slightly more, flexible approach than the majority opinion.
More flexible in what way?
Well, while I definitely understand the concerns about lawsuits overwhelming the courts and the difficulty of figuring out what's truly going on in an officer's mind, I think I would have been more open to allowing a retaliatory arrest claim to move forward, even with probable cause, if the person could present some convincing evidence suggesting that the minor offense was really just an excuse, a pretext, and that the real reason for the arrest was the person's protected speech.
So you had shifted the focus a bit more towards the motivation behind the arrest, even if probable cause was there.
Yeah, I think so. And I would have been particularly interested in taking a closer look at that no reasonable officer would have arrested standard that we talked about earlier. I know it's kind of subjective, but I think if it's fleshed out a bit more, maybe by focusing on established police practices and how they typically handle similar minor offenses, it could be a useful tool for preventing those kinds of retaliatory arrests, especially when you're talking about petty offenses where there isn't a pressing need to arrest someone immediately. Like, was this really a situation that called for an arrest, or was it something that's usually handled with a warning or a ticket?
So you'd be looking at the bigger picture, not just the immediate circumstances of the arrest.
Right. And honestly, I have some concerns about the majority's focus on this objective evidence of other people being treated differently. It seems like it could be pretty hard for someone to get that kind of evidence, especially in the heat of the moment. Like, are you really going to stop and ask other people if they were arrested for jaywalking after they criticize the police? It doesn't seem very realistic.
So you'd be looking for a more holistic approach, considering all the circumstances, not just this very narrow type of evidence.
Yeah, I think so. I'd want to look at the sequence of events, what was said, how the officer reacted, and whether the stated reason for the arrest really makes sense in light of how the police usually operate.
So it'd be about looking at the totality of this situation.
Exactly. At the end of the day, it's about finding that balance, right? Protecting the First Amendment, but also respecting the legitimate needs of law enforcement. And I think a slightly more flexible approach would help achieve that balance.
It's a really thoughtful perspective.
Yeah.
And it definitely highlights the ongoing debate about how best to navigate this complex issue. It's clear that there are no easy answers, even at the highest level of our legal system.
Absolutely. It's something we all need to be thinking about and talking about because these issues affect all of us.
Well, this has been a fascinating deep dive. Thanks for joining me.
Thanks for having me.
And to all our listeners out there, keep those brains engaged, and we'll see you next time for another deep dive.